Guys, you really have to see this. Judge Torres to dismiss sex motion in Remedies phase. According to attorney James Murphy, who is also known as Metal Woman by the XRP Army, the justifications that the United States Securities and Exchange Commission is using to argue that injunctions and disgorgement are insufficient are weak. And Judge Torres has the ability to reject the SEC's allegations that institutional investors have experienced monetary harm. James Murphy, a lawyer who supports XRP, stated in a post on X that the United States Securities and Exchange Commission's reply brief does not offer anything significant to the case that institutional investors have experienced financial harm. Ripple Labs is being asked to pay a disgorgement of $876 million by the Securities and Exchange Commission on the grounds that some institutional investors have been harmed. Despite the fact that Ripple contended that the precedent set by the Govolk held that the SEC does not have the right to disgorgement if there is no financial harm associated with the purchase. In part, the motion for $2 billion in sanctions that the SEC submitted will most likely be denied by Judge Torres. However, according to James Murphy's reasoning, it is still inappropriate to use a decision that has been designated as not for publication as a precedent. In any given case, these are deemed to be the least authoritative precedents. On the other hand, he does not completely discount the chance that Judge Torres may follow the argument presented by Afresh. In addition, it is conceivable that the judge will decide to hold a hearing in order to resolve any questions that remain unresolved regarding the positions taken by the parties. In response to James Murphy, attorney Jeremy Hogan stated, "Before citing to those cases, you are required to request permission from the appellate court. Given that Ripple has not provided a response, it is hoped that the judge would notice it." The SEC, according to Murphy, relies on a case that was heard in a district court called SEC versus Afresh. In that case, the court ruled that the pecuniary harm threshold is proven when a stock price is artificially inflated. Ripple is accused by the SEC of manipulating the price of XRP in an unnatural manner using a variety of methods, including use of automated bots. In the past, executives from Ripple have repeatedly refuted allegations of this nature. Fresh's ruling, in my opinion, is a misinterpretation of the holding that the Second Circuit Court of Appeals made in Gavel about disgorgement. It is also interesting to note that the judge who penned the Ifresh decision labeled it as not for electronic or print publication, as stated by Metalman. The Securities and Exchange Commission contended that certain institutional buyers experienced financial hardship because they obtained a lower discount on XRP in comparison to other buyers who paid a higher price. As the SEC finalizes its replies, the Ripple XRP lawsuit draws nigh. Reportedly, the U.S. Securities and Exchange Commission's final response to the Ripple Labs litigation has been filed. SEC has been disputing Ripple's claim that it did not engage in any hazardous behavior regarding the sale and distribution of XRP coins since 2020, and this new submission is a critical step in the remedy stage of the action. SEC continues to bolster its argument against the blockchain startup. Although Ripple denies any reckless behavior, the Securities and Exchange Commission has warned that the company cannot rule out the possibility of similar violations in the future. The regulator further notes that Ripple's past actions raise concerns about the likelihood of future breaches, which could necessitate further legal action. Ripple will be deterred from future violations of the aforementioned charges by the penalty that the SEC plans to impose through this action. The SEC is challenging Ripple's legal changes. The filing by the Federal Securities Commission runs counter to Ripple's understanding of the prior court rulings and the changes the company plans to implement to its operations. According to Ripple, depending on the result of the opposing side's legal procedures, the company may restructure its XRP sales and operations. Ripple is facing criticism from the Securities and Exchange Commission, which claims that their intentions are based on a faulty reading of the court ruling and do not meet all the legal requirements. The commission also criticized Ripple for continuing to limit XRP sales to accredited investors and those outside the US, despite the dismissal of these arguments during the summary judgment phase of the lawsuit. Finally, the regulatory body rejected all of Ripple's changes to its on-demand liquidity sales contracts, citing the absence of restrictions that were previously cited as violations of XRP and future developments as the reason. Despite the challenging legal situation, Stuart Alderodi, general counsel for Ripple, remains optimistic that the litigation will be resolved in his favor. A final decision is expected in September, and the cryptocurrency community is eagerly awaiting the outcome of this court proceeding. Alder publicly criticized the SEC's legal strategies in response to their most recent methods, stating that they would be detrimental to the SEC's reputation. In contrast, Ripple has recently formed a strategic partnership with the Tokyo-based consultancy firm Hashi. The goal of this agreement is to bring Ripple's XRPL enterprise solutions to the Japanese market. This shows that despite the legal issues it is currently facing in the US, Ripple is determined to establish a global presence. The outcome of the dispute between Ripple and the Securities and Exchange Commission will have far-reaching consequences for the cryptocurrency market. In the ongoing legal process involving XRP, the US Securities and Exchange Commission has submitted its redacted Remedies reply brief and accompanying exhibits. During the meeting, Ripple's chief legal officer raised numerous important points about the files and the commission's application of the law. This case could become a landmark in the USA's ability to set standards and methods for recognizing the existence of value in digital assets. It will affect many participants in the blockchain and fintech industries. The allegation states that Ripple has assured the court that it does not need to worry about violating U.S. securities law. Ripple has done this by pointing to its various licenses, which do not consider XRP sales as securities sale. The commission argued in the documents that this reasoning is nonsensical, like saying a restaurant in New York does not need to seek a liquor license just because it has a fishing license in California. On May 8, 2024, the public was given edited versions of the Ripple case. Following that, the two sides will meet to discuss the desired redactions and any other parties involved. After this, on May 13, the parties will send a menacing letter to the court to seal the materials related to the remedy briefing. On May 20, Ripple, the SEC, and other third parties will file their opposing briefs. It is expected that the upcoming filings in the SEPI Ripple lawsuit will impact the future price movement of XRP. This is because XRP is still significantly behind the competition due to legal hurdles. He continued by saying that this argument causes financial discomfort for institutional buyers of XRP from RippleSEC. However, RippleSEC's reply brief does not add anything new to the argument about the possibility of financial loss. Experts' question is whether the financial harm can be applied to a situation where an institutional buyer makes a profit but could have negotiated better terms and made a larger profit. It's worth noting that the Securities and Exchange Commission is trying to define financial harm very broadly and is arguing that Ripple interprets it too narrowly. In his response, Morgan said that the commission's reasoning seems more convincing now than it did at the beginning. Ripple's focus on redacting discounts shows how important it would be for institutional buyers, as pointed out by the watchdog. Afterwards, he brought up the issue of permanent injunctions and the potential for decreasing or limiting them. Before making any investment decisions, we strongly recommend performing independent research and consulting with an experienced professional. We do not take responsibility for any investments made based on the information provided on this website.